behalf of IIQS, I welcome all of you and it's very happy New Year to all of you. Now, to introduce today's speaker, may I call upon Mr. Kalpesh.
Good evening, friends. I'm here to introduce our speaker today, Mr. Dharmendra Pardasani. I think most of the people in this room know Mr. Dharmendra very well. He is such a person that he hardly requires an introduction. However, for people who are new here, let me introduce Mr. Dharmendra. Mr. Dharmendra Pardasani is working as a Programs Director Contracts with Parsons Overseas Limited, and he is with Parsons since last 18 years. Mr. Dharmendra has completed his LLM in Construction Law and Arbitration, MSc in Quantity Surveying, and holds a bachelor's degree in Civil Engineering. He has over 30 years of experience in the field of cost planning and cost control, commercial management, contracts administration, contractual claim, project planning, dispute resolution, risk management, and value engineering. Mr. Pardasani is a fellow of Royal Institute of Chartered Surveyors. He is a fellow of Australian Institute of Quantity Surveyors, and he is a fellow of Institute of Arbitrators, and a corporate member of Chartered Institute of Building. He is an ex-board member of RICS MENA Region Knowledge Board and Education Board, and a vice chairman of UAE Council. So friends, please join a hand in welcoming Mr. Dharmendra.
Good evening, friends. Is it okay? The mic is okay? Yeah, okay. So great to see all of you, so much of numbers. The session of whatever is going on, I think Dubai is really making most of it, because in other Emirates and they were depending on oil and all, Dubai wisely and judiciously had so many other things, and that really is on this day when things are going not that well with the oil prices and all, because of judicious planning or whatever vision what Dubai had. It is because of that Dubai today is doing better than all other Emirates and all other countries in the Middle East, and that's a great sign of vision of Dubai government. And today this is a presentation to avoid disputes in construction contracts. We all try to avoid the disputes while we are at pre-contract stage, but finally what happened, we all know that in spite of all our efforts, finally we do have disputes and somehow we can't escape it. But this particular issue of trying to do our best at pre-contract stage and then trying to avoid dispute, that reminds me of one of my friends in Alain. He used to appear for his driving test. And in Alain that time, now a lot of signals are there, but that time most of it did not used to be roundabouts. I think maybe some of you are old in the way, you would remember that Alain was full of roundabouts. So every time he used to fail. So I used to ask him that, okay, what happened? He said, roundabout, this time I entered and the police guy said that you are too rash, you should have waited for that car who was coming from the left, or you were too rash to enter. Next time again he failed. I said, now why you failed? This time I entered and I was waiting and until all the cars go, and the police guy was saying that, do you want to sleep here or what like that? That time again he failed. I said, what happened now? You took 40 hours of classes or 60 hours of classes, again you failed. This time what happened, that I did everything right. I said, then why you failed? This time what was the case? The inspector, as a normal routine, he is supposed to clear only 2 to 3 candidates in a day, and that particular morning others performed well and he cleared 2, 3. And by the time I had done him, and so he had finished his quota. So what happens is that whatever we do, finally it all depends on how others behave and how the roundabout is good or bad, or how whether other candidates have passed this morning. So it all depends whether finally we are going to have the disputes or not. But the advantage of doing your best and avoiding the dispute, advantage is that you will earn a good name for you, that you did very well and you avoided disputes. But advantage of not doing very well and having disputes in the contracts is that there are 2 advantages. One thing is that your job will be longer, you can be on site for a long time. And second thing is, that you will have a lot of topics to give to RICS people for APC. So many people don't have topics, but if you have dispute, you can always sell those topics to them that yes, this is what I did, and three options of paying, not paying, and partial paying. So all those options you can give them. So anyway, so this is this was on the lighter side, but the fact is that yes, we surely need to do our best at the pre-contract stage. Sometimes what happens is we are involved only at the post-contract stage and we don't get the chance to be involved in pre-contract stage. That time we blame others that okay, our pre-contract team, they did not do well, and if they would have done this way, we would have avoided the dispute. But when our turn comes to be involved in pre-contract, that time we because of urgency of submitting deliverables or so many other urgency issues with that time, we forget to do what we thought that we would be doing in the pre-contract stage. So that's why surely it is all of our duty that if we are at pre-contract stage, we need to do best to avoid or to put those kind of provisions that avoid dispute. If we are at post-contract stage, then also off and on we get the chance that when we are on site, we keep on passing our concerns to the pre-contract team that okay, yeah, this is the issue what we are facing inside. Next time, please make sure that this issue is addressed, and that kind of procedure we need to keep in place as far as practical and possible. So, like in this presentation, there are like few random items that I put in the presentation. From my experience, that those particular issues, in all the contracts, they create some contention or disagreement. So from that perspective, it is not in any particular order, but surely this kind of discussion will help us to address those kind of issues. And for RICS interviews also, some of our friends who are applying for RICS interview, surely it may help there also during those discussions. Okay, like the items which are the topics which are there, priority of contract documents, which creates many time contention, extension of time very well developed, concurrent delays, nominated subcontractors, site conditions, variation, site obstructions, quality of works, practical completion, maintenance period, and dispute resolution. These are the items which I think would all agree that these items do create a lot of issues on site. Then in section B, there are like few do's and don't do's. And section C, the small 1 or 2 slides which relates to the precautions or the care which we need to do while drafting, design and build the contracts. Okay, like priority of contract documents, most of the standard contracts, they do have priority of contract document, but in case you are faced with a contract which does not have, surely you need to specify the priority of contract documents. And while in case you are made to define the priority of contract documents, or you are made to alter the priority of contract documents in a standard contract, make sure that while doing so, give priority to the specific documents over the general documents. Like for example, if you have general specs and you have particular specs, always put particular specs as a priority over general specs, similarly for condition of contract. And chronology of the document normally govern the priority. So whatever the latest document, that should be the first priority. So if the letter of acceptance is the last document prior to forming contract, that should be the first priority. Post-tender correspondence, if that is the one step before the contract award, then that should be the second priority. So in order of chronology, that because as when the contractor submits a tender document, then there are discussions and there are withdrawal of qualifications or additional qualifications, as based on the chronology, normally it should be that way, priority. And in case 2 or more documents carry equal priority, that's what in FEDIC it says that many documents in the 5th item says normally drawing the specification that carry equal priority, and we must put in the contract that in case those documents are having equal priority, so the documents should be read mutually explanatory of each other. And one thing that we remember that we need not put in the contract, but in case of contradiction between two documents, that yes, if in spite of priority, in spite of interpretation of that ambiguity, making use of priority, in spite of that, finally it is nailed down to the this issue that yes, there is a contradiction and there is ambiguity, then the contra profundum rule governs, which is the party who has drafted the contract document, the ambiguity goes against him. So in most of the cases, since client or his advisor or agent would have drafted the contract document, so surely that ambiguity will go against the employer, and that's why when we are working for employer or as a consultant to employer, the employer is relying on our risk to make sure that we don't allow any ambiguity in the contract to creep in, which will go most of the time against him. Okay, like extension of time and associated cost. There are like, okay, extension of time, every contract has a clause for extension of time, but in spite of having all the clauses, we still are faced with 4 or 5 issues in all the extension of time. Whenever any claim comes, we are faced with those uncertainties. So like first is like delay by external authorities or service authorities or external stakeholders. Is it a valid delay claim or not? So FEDIC and most of the time, most of the other condition of contract what I have come across, it doesn't say clearly that in case of delay by other authorities or other stakeholders whether that is a valid delay claim of an event or not. So when we submit a claim, the answer comes from other side. See, this is not a delay by the client, this is a delay by others, and you should have anticipated this one, knowing that most of the time contracts are delayed by others. So, but again, this is that kind of risk which not wise to pass it on to a contractor, but okay, but in case the client wants to pass the risk to the contractor, so we must say so clearly. In FEDIC 99, if you see, it says that delay by other service authorities is a valid delay event, provided the contractor demonstrates that he has done all the required proactive approach in dealing with authorities and all. So that is a like wise way of saying so. But in many other contracts where this kind of provision is not there, we must specify whose risk it is, and ideally, since this risk is very difficult to manage for the contractor, so ideally it should be retained by the client, but again, it is all to the client to see whether he wants to retain the risk or wants to pass on to the contractor this risk. And if he wants to pass on this risk to the contractor, surely the price or the cost related to the risk he should be expecting in tender prices. And one issue which all of you or some of you may not have come across uncertainty. Whenever any variation is expected, that time the issue comes that okay, like it's a 2 years contract and the variation is issued maybe somewhere on 3rd or 4th month. So always the argument comes from the client or from the engineer. So what? So variation is issued, you still have 1.5 years. So how should it delay? Will you put more resources and finish off this variation? Why should it delay you? Even if it is causing any obstruction to any of the path, maybe 2 months later or something, it may obstruct. If you don't do the variation now, it may obstruct you after 2 months. But you put 100 more labor, put additional resources, and you can finish it out. That time the contractor's argument would be or is normally that I am at the peak of my, I am already struggling to cope up with my delays. I am already put my labor according to my original baseline program. That is what I have anticipated, and I never anticipated that I will have to increase my labor from or my resources from what I have anticipated. Yes, when my labor resource curve, when it goes up, when it comes down, that time when it comes down, instead of removing those resources, that time I will take care of this variation, because that time instead of demobilizing my resources, I will do the variation. So it is not clear in the contract that is it really required to increase the resources or take care of that variation with existing resources, and instead of demobilizing you should. So this kind of thing, if you make clear, it is not easy to make it clear, but these things are, today's slides are actually not to give you any 100 by 100 solution, but just to draw your attention that these things do create problem, and if we can think of any solution or any way out at the time of forming the contract, it will really remove or reduce a lot of uncertainties later. Then another issue comes with the extension of time, that like which approach we are going to use. Most of the time, we are not planning engineers, and we all only have read in the books, there are 3-4 methods, and that time, all the champions will come in. One will say use land impacted, other will say, use this time impact analysis. All ideas will come in and just to confuse each other, and contractor, he will say that I cannot use this method, it is not written in the contract, and all those arguments start unnecessarily. But if we are refining what approach is agreeable, or what approach should be adopted in the contract, if you put it, then less of argument. So I think most of the time, from our experience, I think we would have known by now that yes, land impacted has a lot of limitations. Then as-built collapse is very complex method. So then I think the wise way or the rational approach is the time impact analysis. And if you are doing a retrospective analysis, then the window analysis is reasonably good approach. If you are doing prospective analysis, then a snapshot analysis, which is taking the monthly progress update and seeing when the delay happened and using that particular progress update, that is a reasonably good idea, good way of dealing with extension of time. And in most of the arbitration and the courts cases wherever it has happened with this kind of uncertainty, the adjudicators or arbitrators have preferred this kind of approach. So why not to put it in the contract? We were attending a presentation with one of the major clients 2 days back, who have changed the condition, and they actually have put this kind of thing now in the new contract, that yes, this is the approach that we need to follow, instead of leaving it to everybody's discretion. Then another issue, surely it comes in whenever we are working out this cost, contractor is submitting the cost and we are assessing the cost, whether head office overheads are payable or not. And all the arguments what starts, contractor would say, my head office is working and I have got 4 projects, this project is prolonged, so I should be getting 25% of my cost, which is allocable to this project. That is his normal argument. And from the other side, the argument will be whether the project would have prolonged or not, your head office was working. You need to demonstrate what the engineer or the client will tell the contractor. You need to demonstrate one of all the 3 things. That in case project would not have prolonged, you were planning to close or close your head office, then yes, we can agree for head office cost. Or because of prolongation of the project, you have to incur like more head office costs, that okay, your accounts people or your other people are working late hours in the head office to tackle with this project, or you have to incur more telephone calls or electricity calls, which is not easy to demonstrate for the contractor. And third, what evidence they will ask contractor to demonstrate, that on a balance of probability, like you need to demonstrate that you really refuse some new projects in the market, that because of this project of prolonged, you refuse new projects in the market, and because of that, your head office cost, which you could have allocated to that project, which you would have won, now you have to allocate because you refused certain tenders in the market. And even if you refused, what was the probability that if you would have participated in any new tender, you would have won? So show from a record of your previous 10 submissions that how many submissions of tenders you did and how many you won. So all these kind of arguments will come. So it's okay, like all these arguments are valid and are the right arguments from each side. But it's better put in the contract, head office overheads are payable or not, and if it's payable, put a formula or whatever way you want to pay for the head office overhead. Then this issue of cost escalation. This is another issue that in most of the contracts, in the virgin form of contract or in the original form of contract, most of the forms of contracts will have cost escalation clause. But what happens that in 90% of the contracts we remove that cost escalation clause. If cost escalation clause is there, then no issue. Extension of time is there. Some of the works which you were supposed to do during original completion that date, that will get extended by say 6 months. No issue. During that 6 months, if the cost indices is increasing, he will get the cost escalation for that period, so no dispute. But when we are removing the cost escalation clause and not putting any associated provision that in case of extension of time, whether contractor is entitled for cost escalation or not, then it leaves things to uncertainty. You see from contractor's perspective, 2 years contract, he has priced for the cost escalation for 2 years, fixed price contract, no issue. But if the contract is exceeding by another 1 year, so that additional escalation he never priced. So it means, is he required to take that kind of risk at the tender stage, that assuming that there will be delay by the contractor, he will get an extension of time of 1 year, so he should put a risk of cost escalation of 1 year? Surely no. If he keeps on putting this kind of price, this kind of risk, he will never get any, he will never win a tender. So this is the thing which we need to clarify in our contract. Then another fight starts whenever any extension of time, that cost should be based on prelims, which is general items contained in the contract, or actual cost. Then since the contract says word cost, so then the argument starts, the contract will say word is cost, so I will claim my actual cost. The argument from other side starts that okay, that is fine, cost you claim, but now if your per month cost based on the actual cost is say 2 million dirham per month, based on the BOQ in the general item it is say 800,000 per month, so you are incurring absolutely unnecessary cost which is related to your lack of maybe your productivity or your inefficiency, or you're wasting your resources. So okay, we'll pay for the cost, but reasonable cost. And what is reasonable, that nobody knows, like whether 2 million dirham per month is reasonable or 1 million, or then it starts unnecessary discussion and argument. So let us put it clear in the contract whether it is based on the general item, in the time related items in the BOQ, or if it is actual cost. Then like actual cost means actual cost, whatever it is, instead of leaving it to subjectivity or reasonable cutting, chopping, and leading to unnecessary disputes. And then this finance cost and loss of interest, this again is, no contract is clear. Whenever a contractor claims of finance cost or loss of interest, then we start going to UAE law. Oh, that UAE law, the contract would not say anything. Then the UAE law, then most of us can't interpret that one. Then we'll go to lawyer, and lawyer will give you advice which will confuse you further. Unnecessary, this uncertainty and leading to dispute. Better put it, payable or not payable, simple, and finish it up. Then this, this champion item comes concurrent delay. Whenever an extension of time comes, I think most of the contractors, they know that what kind of harassment it is, when the concurrent delay. That surely that first that other party will say yes, time no problem, but cost no, because you are concurrently delayed on many items, and the contract would not say what is concurrent delay. Concurrent delay again, there are two types of concurrent delay. The delay event in case contractor is delayed and client also is delayed him. The delay which occurred at the same time, and the effect of delay is also at the same time, at a different time, but at the same point of time. Second is, okay, the delay occurred at the same time, but the effect will be at different times. Third is that delay also occurred at the different time, and the effect of those two delay also at the different time. So, and then the third issue comes, the efficacy of delay. If say contractor has delayed himself with submission of 2 shop drawings, and the client has delayed him to proceed on any work altogether, then is it an equal delay? Is it efficacy of delay equal? No, surely no. Or vice versa, if client has delayed him for 1 shop drawing, while the contractor has not even mobilized on site for 2-3 months and is delayed, it is not equal delay. The efficacy of delay is not equal. So when we first thing is, most of the contracts would not have provision for concurrent delay. Then in case of concurrent delay, cost is payable or not. Then we start going to case laws, and in between some people who are LLM and all, they start poking there, this case and that case and that case, and then other person will come that this case was there, but 1 week back there is another Scottish case where so all those theorems and interpretations and all these things start. So I have to go into all this, and so we can manage all this issue without doing LLM or without calling any lawyer. Let us put it in the contract, that in case of what is concurrent delay, are we talking of true concurrent delay which is the same time, same effect and same efficacy? And okay, in case of concurrent delay, still are we talking of apportionment? or is still absolutely no cost in case of concurrent delay? Can we adopt some approach from SCL protocol which says that yes, in the case of concurrent delay, contractor needs to demonstrate that what cost he has incurred due to his delay and what cost he has incurred due to client's delay. That kind of approach. So I think surely we should think of that, and if we get the chance, we should put that provision. If we don't get the chance, then alas, then God will help. So the civil law articles, which talk of that how the courts may interpret damages in case of concurrent delay, but again everybody would interpret it in a different way. But yes, there are few provisions which, if really required, if there is no provision, we can take the recourse of this civil law, which in my personal opinion does say that in case damages incurred by a party have been aggravated because of default of other parties, so then looks like there is a room for apportionment of damages. So this is this nominated subcontractor. This nominated subcontractor also things are all working well, it's fine, no issue at all. But when the things don't work well, then we realize that if the contract provision was clear, we could have resolved or overcome this dispute. So first, most of the contracts do have provision that contractor can object in case the client is nominating a subcontractor. He can object, but no contract would say that okay, if contractor does object, then what? If you see, if it does not say it does say that the contract should clearly say that okay, if the contractor is objecting, what is he required to substantiate that objection? That it should say so. And if he is able to substantiate his objection, and in spite of that, if the client nominates, the risk is being transferred to client. It should clearly say so. As of now, most of the contracts they don't say so. We imply from that, okay, since the objected and in spite of that client nominated, so risk has been retained by client. But the contract, if you see, most of the contracts do not say all this stuff. And then many times it happens that at the construction stage, the client nominates the nominated subcontractor, and then he says that okay, in addition to he having a subcontract with you, he is also required to have a co-lateral contract with me also with the client, so that in case tomorrow I want to sue him or I want to pursue my rights directly against him, I should be able to do so. But that again should be mentioned in the contract that okay, the nomination will be there, and also the nominated subcontractor will be required to enter into a co-lateral contract with the employer, and even preferably a standard form of co-lateral contract also should be put in the condition of contract or anywhere in the document, so that there is no unnecessary discussion or argument at later stage that what form of co-lateral contract, how much rights the client would have over the subcontractor. So these kind of things better to put it in the contract. So this is the site condition. The site condition may be, there were building books also, but I am from infrastructure and roads, so this site condition is a real nightmare on site. Most of the contracts will have this issue, and some of you are working on roads and infrastructure and civil engineering projects, you would have realized that if the project is 2 years, initially 1 year the contractor will be working on underground utilities, diversion and new utilities, and that 1 year is a mess. That 1 year, lot of claims, lot of notices, and all those issues will be there. Can we, okay, surely we cannot eradicate or cannot mitigate all those delays, but what we can do? Like, first thing is that when we are tendering a job, so the job should be tendered after having done the ground investigation, which either there is boreholes or site investigation or site survey, everything should have been done prior to tendering a job. Then as-built record, surely we should be having a proper as-built record from all the service authorities, and based on that, we should be finalizing our design to avoid or minimize these kind of disputes. Then site inspection, what happens many times, when the contractor submits a claim for site obstruction, we write to contractor, no, this should have been seen by you during tender stage as a part of your site investigation. But sometimes if you ask the client or the engineer, they themselves would not have gone to the site at the time before preparing the tender document. Easy to tell to others that you should have gone to site and you should have investigated. But we, in case I am from consultant or some of you are from client, it's our duty also, the design team, to actually go to the site and see the site and then only finalize the design. Because many issues can be resolved if you really go to the site and then finalize our design. Instead of simply telling the contractor that you should have gone, and yes, his duty also is there. Contractor, I am not saying that, but it is everybody's duty, not only him. Yes. Then different perception of this enforcing ground condition. This also we need to little bit clarify in the contract, because what happens as soon as the site condition, any obstruction, anything comes, the reply from the client or the engineer comes, oh, this is a reasonable condition. You could have or you should have, as an experienced contractor, you could have foreseen or could have anticipated this condition. Okay, yes, surely as an experienced contractor, he is required to anticipate or foresee or put that risk. But leaving this to such a subjectivity that what is foreseeable, what could have been anticipated, better to little bit clarify that, okay, yes, contractor is required to go to the site as a part of his prior to submission of bid. But is he required to go and start doing soil investigation there, start doing boreholes? No, surely not. If 8 tenders are participating, 8 tenders will take their boring machine and start going to the site and digging boreholes. Prior to tender doesn't make sense. And nobody will allow also. If you go to the site with their boring machine or this borehole machine and start boring, somebody will ask that, who are you? I am the tenderer, I am tendering for a job, so I want to see the soil conditions, and that's why I want to see. Get out of from here, and you don't have NOC, or how can you start doing boreholes there? So we need to, we should appreciate that kind of difficulty. So we should put in the contract that what kind of site investigation we are expecting the contractor to do at the pre-tender stage. Let us be more clear. Instead of, I think looks like, we don't try to be clear, so that, we can take advantage of that lack of clarity later by saying so that, you should have done. No, okay, we are trying to be smart, but again the contractors are smart. They know that, this kind of harsh thing is there, and they will put all that money as a part of the risk. So it is not like that. We are not smart. Actually, we are like passing that risk and getting the tender prices against that risk. So these are the things which we should put in the contract, that what is the extent of ground investigation or site survey or physical site visits contractors should do, so that all contractors, 8 contractors are quoting the job, all the 8 know that this is my responsibility and this is the risk. So in the uniform basis of tendering. Then this is the variations, once the project starts, 2-3 months no issue, and once the actual work starts, then the variations start coming. The first thing, which is, at least I have not seen in any contract, what is the maximum percentage variation that can be restricted. If project value is 200 million, can the client restrict another 100 million or 50 million or 80 million, 200 million? Yes, PTIC does have a clause which says that additional works which are necessary and appropriate. But again, that is a subjective issue. Subjective, this provision, what is necessary and appropriate, and it also says necessary and appropriate and required for the permanent work. If anything is required for the permanent work, that would be part of the original contract. When we are saying the word additional work is not additional work. How it can be required for permanent work? So that very term additional work in a variation clause, that clearly says that yes, the client wants to keep that provision of restricting any additional work, and but combining it with this necessary and appropriate, or those things are not compatible with each other. So I think we should, if opportunity is there for us, we should, in my opinion, we should put a percentage that yes, up to this percentage, whether you put it 25, 15, 20, up to this percentage, BOQ rates will be valid, and no argument on rate. But yes, if the variation exceeds beyond that percentage, then the parties can agree a fair rate in case the rates are changed at the point of restriction or variation. And again, if it's a 3 years contract and the variation is restricted at the 2nd or 3rd month, so definitely we would not expect that prices would have greatly changed. But if the variation is restricted, say after 2 years and 6 months, and the contract period is 3 years, so surely prices, we can expect a lot of changes in prices as compared to when the contractor had quoted for the tender price. And then another argument starts that in case of variation, whether low rates or high rates are applicable or not. Then again, we started going to case laws that in that case this happened and judge allowed for the high rate and the other judge did not allow for the high rate and he said no reasonable rate. And then other argument starts, no, engineer can fix a rate or one party can notify for change of rate. All those arguments are not correct, because all those arguments which are in FEDEC notification, those notifications are only related to those circumstances where nature or quantum of variation is different to nature and quantum of the original work. Those notifications are not because of if any rate is high, so client will notify that, oh sorry, I hereby notify you that in case of variation this rate won't be applicable. That way, once the variation is instructed and it contains 20 items, for 10 items contractor will notify, I hereby notify you that I don't agree with these 10 rates. For other 10 rates, client will notify which are high rate, so variation can never be agreed. So those notifications are not for this purpose. So we should clearly once for all say in the contract, yes, whatever low high rate, both the parties have to honor in case those rates are applicable in context of nature or quantum of variation. Nature and quantum of variation is such that that particular rates are applicable, then regardless of low or high, it should be applicable. So we should say so in the contract, if possible, if we have the authority to write so. And then again the extension of time, as we discussed, that in case any extension of time is there, and during extension of time if any variation is instructed, again is contractor required to do at the BOQ rate or can we agree a fair market rate? That also better to clarify. I know many cases where the contract was 3 years, there was an extension of time of 2 years to 5 years to went. At end of 4 years and 11 months, variation has been instructed, and the argument was, see, there is a clause for extension of time, we are giving extension of time, it's a fixed price contract, no cost escalation, and so the BOQ rates are applicable. All those arguments come. If the cost escalation clause was there, then no issue. Whatever time period variation is instructed, cost escalation is clause is there. If the variation is instructed at 5th year of the contract, like during the extension period, no issue, because contractor will get his cost escalation and it will be fair reimbursement. And then the modus operandi for head office overhead, that we discussed, that they should be, if the head office overheads we are agreeing, better to put a formula, whether Hudson or Ashley or Hanklin or Dr. Samarananga formula or whatever, like, better put it and then we'll finish it off. And site obstruction, I think we discussed before, I think we'll skip this slide. Okay, maybe one additional point, that rock, sometimes we are having an item of rock excavation in the bill of quantity, and then the dispute starts that some hard material has been found on site, which is causing contractor to incur much more effort as compared to digging a normal soil. So his claim will be that this falls under rock, and so then again the discussion starts, what is the definition of rock. So if the contract is very clear in respect to definition, good. If it is not clear, better make it clear and come out of this issue. Then the quality of works, it does create a lot of issues. Anyway, this is not a much of commercial issue, but just to go in a fast way, that okay, we should have detailed specifications for all the materials, and especially warranties. And if you see any contract, there will be like 20 places for different material. One place it will say 3 years, other place will say warranty for material 4 years, other place say 5 years. And then in another contract, you are also confused that finally you are scrolling the pages for this material, where is warranty written. Better to put it tabulate at the end of the specification. There are like 50 materials or 100 materials to be used in the contract. What is the warranty for each of the materials? If it is tabulated form, no confusion. At the end of the contract, or for contractor also to negotiate with the suppliers, instead of scrolling through each page and trying to find where is the warranty written. Here the tabulated form is excellent. And putting this source of material. If you really want contractor to source the material from one or two specific sources, we should say so. Of course, one source surely we should not say, but at least 2 to 3 sources we should say. If we don't say so, and during the course of the contractor is proposing material from some supplier, and we don't want from him, and somehow we are trying to reject that one without saying that go to that supplier, and that is the argument is start. Oh, that supplier is giving at that price. Now you are trying me to divert with the supplier. That will cost me that price. So why do you play hide and seek? Want 2, 3 suppliers, put it and finish it off. Instead of trying to play hide and seek with the contractor. And this practical completion. This again a contentious issue that once the project is completed, at the stipulated completion date, everything is going on well. But in spite of we all know that on the stipulated completion date, whatever best the contractor does or contractor would do, things won't be 100% complete. It will be substantially completed. That's why most of the contracts do have the word substantial completion. But the definition of substantial completion is not there in any other contract. At least I have not seen. So we should though if you refer to books, lot of definitions are there. So why not research 2, 3 books, take good definition of substantial completion from those books, like 2, 3 main points, like the client should be able to beneficially use the works. In terms of safety, it should be okay. In terms of aesthetic, it should be reasonably okay. In terms of passing of tests, it should be reasonably. We should have passed all the tests. Just put that one and define the substantial completion. And if it is required to even put some percentage completion as a minimum thing, so we can put a clause there. Okay, these are the few things surely should be completed, and the engineer should take a holistic view, and then minimum percentage completion should be 96-97%, but that should not be the only criterion. The engineer should take a holistic view of percentage completion plus all these factors to arrive to a conclusion whether the project is substantially completed or not. If you put this kind of few provision, it will help not only the contractor, it will help the client and the engineer also later to decide, yes, on this date whether we can consider the project substantially completed or we should issue only partial TOC because few works are left to be done, or these works can be done by the contractor during defect liability period. Easy to take a call at that stage for the engineer. Then this issue of maintenance period, or some contracts we call it as defect liability period. There are again a lot of misconceptions about this period also. Is this period for maintenance of the works? No. Though the word says maintenance, but actually this is not the maintenance period. This period is for attending any snags and defects, patent or latent. So on the day of issuance of taking over certificate, some patent snags will be there, which will be notified by the engineer or the client or the contractor, and he is supposed to do those during this 1 year period. In addition, during course of 1 year, few more latent defects will be found out, those will be issued to him. So that is what is it's not supposed to maintain the work. So maintenance should be done by the client who has taken the care of works on the date of issuance of taking over certificate. So maintenance is his client's job, and he should maintain to make sure that no unnecessary snags or defects appear during maintenance period, which should not have appeared if the works are being maintained properly. So maintenance is a separate issue, and attending the snags and defects which are a result of error, omission or negligence of contractor during course of the work, that is a separate issue. If the defects appear because the works were not being maintained by the party who has taken over the work, it is not ideally contractor's issue that to take care of those defects. Again, damages caused by accidents, vandalism, and all know that once the care of works has been passed on to client, it is his, he has to take care of that. And if you put this kind of provisions, in this contract, it is always good to have clarity. Because many of us, we are not really certain about all this, and clients are surely not, very certain, because many times, this issue of maintenance is this job, and so better to make it clear. Now this dispute resolution. Dispute resolution, I think most of the contracts here in UAE, or maybe says 70 to 75% has this arbitration clause. But most of the time we are not sure that, okay, if we want to put an arbitration provision as a dispute resolution provision, the provision for arbitration clause should have minimum few things which should be stated in the contract or in the arbitration provision. So, of course, this arbitration is a big subject, and we can talk about some. Mr. Venkat also many times he has given seminars on this one. But a few things, which surely, even if we are not legal experts or we are not law savvy or whatever, but then these are very easy things that clause should say that all the disputes arising in or out of the contract should be have to be referred to arbitration as a first dispute resolution mechanism. And it should also say the person who is signing the contract should also have the capacity to arbitrate. It is not necessary that every person who has the capacity to sign a contract as per his power of attorney, he also has the authority to arbitrate. It is not a must. So the person who has the power of attorney, it should clearly say in his POI that he has the capacity to sign the contract, and also he has the capacity to arbitrate in case of any requirement. Otherwise, there are many court cases in UAE where this arbitration awards were rejected by the courts because the party who had lost, he had raised this objection on the grounds that our person who had signed this one, he did not have the capacity to arbitrate, and according to this arbitration clause is invalid. Then better to say that place of arbitration. What will be the place of arbitration? Applicable procedural law should be mentioned, whether UAE civil law or DAFC law and all. That okay, like procedural law means when we are talking of DAFC law or DIAC law, so there is small typing error. Then the rules of arbitration should be mentioned. That if we are going to do the arbitration under a professional body, whether Dubai International Arbitration Center or DAFC, which rules we are going to follow, we should say so. Composition of arbitration tribunal, whether 1 or 3, we should say so in the arbitration provisions. Language of arbitration should be stated. And separatability of arbitration clause. Separatability means in case tomorrow the contract is made void by the court because of it was written in such a way that it was not a certain contract, and there were so many ambiguities, clause, there was so much of issues with the contract. The court decided that okay, this contract is not a contract which is not a legal contract, and it is void. Like at certain stage, at that time it should not happen that the arbitration clause also becomes void. So there should be a clause saying that in case of separatability, in case the contract is void or the contract is terminated, still the arbitration clause should remain valid. So it may not happen that when the contract is terminated by either party, the other party says, oh, the contract is terminated, now arbitration clause automatically is not valid and we directly go to the court now. In case of, when we say separatability of the contract, this one arbitration clause, it means regardless of termination or regardless of contract being void, arbitration clause, because if the contract is made void, still the one party can challenge that kind of void. So I think it should be, if separatability clause is there, that will help. And it should say, though as per UAE law it is there, but arbitration award, it should say that it is final and binding unless successfully challenged in the courts. So I think these kind of minimum provisions we should put to make sure that the arbitration clause works well, and it should not happen that at the time of invoking arbitration, the other party challenges the jurisdiction of arbitration panel that no, this clause is invalid and directly we should go to the court. Then I think last slide on adjudication, that though most of the contracts they don't have provision of adjudication. In Abu Dhabi, yes, it is there, provision is there in adjudication, but this if really miss we have time or energy to study adjudication, we should surely improve our knowledge on adjudication. Why? Because that will help us to many a times to convince the clients that adjudication is one of the good dispute resolution mechanism. That is my personal opinion. But in UK, where adjudication is a must now, mandatory now as per UK's law, there like adjudication has been very successful. So if we have good knowledge about adjudication and then if we are given the opportunity to draft a contract, then we can always propose adjudication. But if we don't have knowledge also, we won't be hesitant to propose. So we should little bit gain knowledge on adjudication and go on that. There are hundreds of articles on adjudication. But this adjudication has been quite successful in the UK. So, and the benefits are speedy decision, less cost, and less amount of formal hearings and less exchange of documentation. So, if we really want to put this adjudication provision in the contract, we should have reasonable good knowledge on that, and then surely in UAE law it does not have good provision for how this adjudicator decisions are going to be enforced and all, but with the time it will change. But as of surely what will happen that if adjudicator gives a award or decision, and if other party is not abiding by that, they can always go for arbitration. That choice is there. So whether in a UAE law there is a provision or not for enforcement of adjudicator's decision, but at least it is a little bit of deterrent for the other party to directly go to arbitration. So it is a good thing. So if you have the time and energy, surely do read about adjudication. It is an upcoming thing. So if you lighter things and heavy stuff is over. So don't do at the pre-contract stage means if you are conversing with one form of contract, don't try to use that form every time with few changes here and there. Yes, there critical got issued 3, 4, 5 different forms. Better read that, study that, so that when the opportunity comes, not opportunity, when the requirement require us to use that one, we should not shy away from that form of contract because we are conversing only with BD 87 Red Book or 99. By studying that one, we will be a little bit more forthcoming with the client. Don't use this form of contract, it is not suitable. Use this because surely we need to update our knowledge. Most of the form of contract which are issued by BD. Then if we are really drafting a contract, which most of the time we won't be doing, don't use passive language and try to include a project brief and avoid using ambiguous and incomplete provision, that I think we all know. And consult the legal advisor when making any major changes to the terms and conditions of contract. It's not that we can't do, no, we can do surely, but sometimes because why the lawyers are one thing is their English and the way of putting things is better than us. Another thing is they are more exposed to disputes and legal issues and court cases, so they know that because of this problem with the contract, this issue happened. So that's why they are in a better capacity than contracts people to advise on changes to the contract. And if we are left to do the changes, so try to allocate the risk to the party who better position to manage the risk, and list of priority, like which document is going to take priority, that should be mentioned, and the mechanism for communication is email is a valid document under the contract, better define it. Otherwise, later sometimes it does create, and somebody will say issued you, informed you through this email, and you will say email is not recognized. It's better to say, not as emails are everybody is using. So better to clarify the contract whether that is an acceptable communication method or not. And surely, some provision for amicable settlement should be there in the contract. Whichever dispute resolution mechanism we put, we should not forget to put amicable settlement as a preferably as a mandatory provision for amicable settlement. So there should be a period. Parties should try. Finally, they succeed or don't succeed, that is something. But at least provision should be there. So that will encourage the parties at least to use the 2-month period. Maybe that you can call it as cool-out period, where all the emotions will be cooled down, and maybe it will give time for the upper management to come into the picture and try to resolve. So that period is important. And just last one slide only for design and build, that in case of design and build, what are the few things which we surely need to do? that, okay, first thing is that, a very good set of performance specifications we need to have for the employer's requirement. Otherwise, if we don't put that one, then all the contractors will be submitting their offers. One will be apple, one will be mango. You can't compare it. Even if the prices are different, you don't know like who's quoting or what. Later, difficult to monitor because those are not based on performance specification. Later, when the contractor will develop that design, you can't control because everything will be left to him. So, a set of very good performance specification / employer's requirement is a must if you are going for a design and build contract. And once we have a contract submission is broken down into a reasonably detailed activity so that tomorrow any deviation from the concept design is there, any variation, those can be reasonably assessed against those broken down costs. And the one thing that client really needs to understand that once in a design and build contract, you can't have that kind of design control what you would have in a traditional contract. So that kind of thing, once for all, client needs to understand that once going for design and build, a lot of authority is passing on to contractor in terms of responsibility of design, and his control or discretion on the design is surely reduced. And in case the design and build contract is tendered based on a concept design, and the client wants that particular designer to continue with the design, then he should put a provision in the contract that it will be innovation, that whatever agreement the client is having with the designer at the development of a concept, the same designer will be innovated to the contractor so that contractor can continue with that same designer. If it doesn't say so in the contract, then contractor will be having discretion. Whomsoever he wants to have as designer, then the client will have no control. Final word, I think this is from all presentations, this is the final word. Okay, a good contract is an investment and all efforts we should do to make a good contract. And a good faith in spite of whatever, the good faith is that if you entered a roundabout in a right time, then regardless of number of people who have passed, you should be passed. So that is good faith that if you feel that somebody is entitled based on a reasonable condition of contract, you should not try to twist those conditions or come to some kind of interpretation, some kind of harsh, unreasonable interpretation that that denies them entitlement or vice versa. Similarly, contractor also should not twist some conditions or make some kind of interpretation in one-sided and try to submit it claim both ways. And UAE article also does promote the good faith, and finally end of the project, if we all have come out of the project maintaining that friendship, and tomorrow once we meet the same person, that CPD, we should not be shy to shake hands just because we had a bad relation on the project. So relations are good, and we all, at the end of the day, we are working for contractor, consultant, or client, doesn't matter. The purpose is to do things in good faith, come up with a project in a win-win kind of thing, good quality, safety, good cost, and a reasonable treatment or good treatment to each other. That is, I think, the real victory for us. Thank you so much.
Practical completion. You mentioned that there is an RACS guidance note on practical completion. That could be a chance to know about it. The other important thing is about termination clause in the contract. In UAE at law, at least, if you want to terminate a contract, court order is required. So, what tips you would be providing, in order to avoid that? That's one thing. Second thing is, if the contractor wants to suspend or go slow because of payment issues, what are the things from the client side you would be recommending to put it as a contract terms?
Sorry, what is the last question?
If there are payment delays.
Okay.
In the unamended virgin fitting, there are remedies available. Most of the time, they are all deleted in this part of the world. So, what would be your thoughts on?
Okay. And going to your first question, that termination courts, consent or we need to approach the courts. This issue is not crystal clear because even in if you consult different lawyers, okay, they may say that, but if you see, attend, I also attended many seminars on this particular issue. Some, one school of thought is that if the contract, it is very clear that, these are the reasons under which or based on which the contract can be terminated. In that case, why should one go to the court and take court's approval? That is one school of thought. Another school of thought, as Mr. Venkata rightly pointed out, some lawyers feel that no, since the under the UAE law it says that termination can be only under 3 circumstances: by completion of the contract, which is very obvious, by mutual consent, or third by UAE court order. But the one school of thought which says that that is okay, that maybe that provision is there in UAE law, but if the contract really says that this is the provision for termination, in that case, and also that the UAE particular that law, it does not say that any provision in the contract in contrast of this provision of UAE law will be invalid or whatever, like how the decimal liability and all. Decimal liability is very clear in the UAE law that if parties try to agree anything any period less than 10 years, that will be like will be invalid. So that's why there are 2 schools of thought. But even I am also from that school of thought that better to approach the court, despite of having that provision, clear provision in the contract that yes, these are the provisions under which we can terminate or client can terminate the contract. Better to approach the court, because in case finally, because the courts also before giving this consent for termination, they will also surely go. If the clause is there in the contract that client can terminate in case of convenience, because of convenience or because of whatever, then on the prima facie, look at that clause, client courts will give consent for termination. But in case the courts are they don't see that and they feel that client is this grounds of termination is not very strong, then they sometimes even ask the client to deposit a certain sum of bond or money, so that tomorrow in case contractor goes for challenges that termination and that matter goes to the court, then there is some surety or bond or whatever with the court. So the advantage of going to the court is that that at least maybe one small doubt in the mind that whether that provision was mandatory or simply we are terminating, ignoring some of the legal provision, that doubt once for all will be done away with, because you went to the court, you terminated the contract based on certain provision. You also respected UAE law by honoring that provision. So I think I feel that surely, because termination is not an easy thing at all. Saying that terminate a contract termination is a real pain, because I've experienced termination of a contract. It is a pain for both the parties, not for contractor. Contractor surely has a problem because he will get the payment once works are rebuilt and constructed, but for client also. Because once the project is terminated, then the contractor will not cooperate at all. Then whatever condition of works from there, you don't have any previous shop drawing, don't have previous record, don't have previous material approval, everything has to be done from scratch. So it is a pain. So I think first point is this, I do agree that if in spite of having provision, if you go to the court and take their order, it is better. Now second question, the remedy for that delayed payment. The payment, I think we all know that more than knowing, we have must have read in all the books that cash flow is the blood of lifeline of contractor. So if you are denying the contractor of his due money what he owes, then it is nothing can be worse than that. So it means because everything in the contractor is required to do. If you see 70-80 clauses in FITIC 87 or 20-25 clauses in FITIC 99, everything contractors do. What client is do, only 1 or 2 clauses, which is one clause is payment. So if the client is defaulting on that, surely he is hurting, harming the contractor in a very expensive way. Now what are the remedies? Now remedies, you let us put ourselves in the contractor's shoes. If you are not getting the money, what is going to happen? First thing is that complete supply chain, we won't be able to pay to subcontractor will not be able to pay to his supplier. So first thing is remedy, in my opinion, okay, so those remedies that slowing down the work or terminating the work, I think that is secondary. In my opinion, the first remedy should be, which is not there in any of the contract. In case of delayed payment, first thing is client should ask the contractor, what is your due obligation of payment to your suppliers and subcontractor. You should collect that, and at least there should be provision that at least that much money will be paid to you. If that doesn't happen, then what will happen? The subcontractor would have given his check to posted check to supplier would have given to that person. Now contractor is not getting paid, he is not paying further, his check will bounce, and that person, subcontractor, will go to the jail or supplier will go to the jail for no fault of him because of delayed payment. And during recession, I think you all know that many of the people, I know some of the people who are PhDs and MSCs and they were working as owners of subcontractors and suppliers, they have to go to jail, no fault of others because slow down payment. That time, okay, contractor got his money after all the claims and surely damages he is supposed to get. But what is the I think this one remedy in my opinion should be there, that all his outstanding payments at that point of time, somehow client owner should be able to pay him and so that he can clear his debt. Then the second remedy would be, okay, that's interest. Like, surely when he is not getting paid, he has paid interest to the bank or he is losing interest, so surely that should be second remedy. And third remedy should be that in addition to interest, it is not only that he is losing interest or another way is without, if he is not getting money from the client, the banks will not keep on financing him. That means surely he needs to slow down the work or agree a revised program, agree a prolonged program, and agree the damages associated with that prolonged program. So I think all three remedies in my opinion should be there. The clearance of overdue debts on immediate basis, interest or finance charges, and third is right to slow down or in case of prolonged delay in payment, then the right for termination also. So I think these all these provisions in my opinion are a must. I think one thing I think also add.
Like in terms of termination, you mentioned that it is necessary to get a court orders or not. See, as we know, like UAE law, it consists of some military laws and the other laws. UAE law also gives preference to the conditions which have been agreed between the parties, unless otherwise it contradicts to the mandatory law. So in case the parties have agreed and signed that they are going to follow particular procedure for termination and all, then the court will be of that view that since it has been agreed between the parties, the termination shall be valid unless, as Mr. Dharmendra mentioned, if it is unreasonable or what. So in our experience and all, we have not said if it is clearly mentioned in the contract, the terms of termination and all, we are not seeing any employer approaching the court to get the termination order, because the UAE law first itself says, okay, these are the provisions by default, these are the provisions of the law for a contract. However, if parties agree otherwise, it will be honored unless it is against the mandatory provision.
It's allowed to ask easy questions also, not difficult items.
Escalation clause is actually freezed in the Dubai market or UAE market. But nowadays all the contractors are concerned about the new service tax and the VAT, etc. How do we properly draft this new legislation going to implement in Dubai or UAE? How do we draft it properly in contract?
See, again, this clause that adjustment of the contract price in case of any change in legislation from the date of or maybe 15 days prior to submission of tender or 1 week prior to submission of tender or date of tender. So any subsequent change of legislation, that should be a ground for adjustment of contract price. So, okay, if all Islamic firms, they do have this provision. Some clients are trying to, remove this provision. Even 2-3 days back, I attended one presentation from a client who was trying to remove this particular adjustment due to change in legislation. So most of the contracts would come for presentation. This was the one main objection which everybody raised, that we don't have a crystal ball to see what is going to happen in 1 year. So how can we take that risk? So surely, as you write, there should be a clause for adjustment of contract price. for change of legislation after submission date of tender.
But this value-added taxes which is going to come
Yeah.
is basically related to the material price.
Yes.
So we don't have a basic rate in here in Dubai.
Yeah.
So how do we analyze at that time?
So see again, surely now if we how do we assess claims? We assess claims based on our best estimate. Now say contract is 100 million. Just a very crude example. The contract is 100 million, and if we go to the BOQ breakdown or whatever do our exercise, from 100 million we expect that based on the BOQ breakdown the materials are say 55% of 100 million is materials, 55 million is materials. Now that material cost, assuming that all the materials are say now exposed to VAT. So it means previously the contract's provision for material was 55 million. Now this VAT has come 12.5%. So how much more is going to incur? 12.5% of 55 million. So these kind of calculations can be done if we don't have any but still all the claims means or estimate that what damages or losses incurred. So we can come up with any these kind of assessment or if the VAT is only for the limited material, then we can go to only 10 items of the BOQ. That these 10 items materials now these are he has to pay VAT. What is the value of this one item? What is the material content of that? And based on this is all estimated when we and then other ways to ask the contractor to demonstrate actual VAT that he has paid. That also is another view. If you are going to pay the claim based on the actual cost, then we can ask him to demonstrate that. Surely you would have receipts for VAT. Because if paying VAT, surely you will get the receipt. So that is another way of reimbursing him for based on the actual cost. And it happened in one of the contract, not VAT, but there was a ruling. And now in Fujairah, like what is happening, I think recently I heard that for every material, every truck, what will pass actually in or out of Fujairah, for every ton of material, the contractor has to pay 7 grams per ton, not per truck, but per ton. So it means if the truck is carrying like 40 ton or 30 ton of material, so 30 into 7 is 210. So it means that now surely contractor would, if the change of legislation is a valid ground, he will ask. Then he needs to demonstrate that how much material came from Fujairah that was equal to how many tons. So that always kind of assessment can be done.
There's one more question. Most of our projects we are preparing for the private clients, not for the corporate clients. In that case, just what you told, make it more clear. Suppose like a preliminary estimate or preliminary estimate of time. Make it clear for Hudson formula, Samudana formula, all those formula. But when we discuss this matter at the time of negotiation, each contractors have their own. No, I cannot agree this one. Other contractors say, no, I cannot agree this one. So it will make a different criteria in front of the client at that time during the negotiation. Is it really required? The client will say, no, leave it all things, do it at practical at that time. So,
now it's not that there are 10 or 20 different ways. There are only 3-4 different ways of this delay analysis. One, the client impacted, which we all know that doesn't work because the baseline program will be at the beginning of the contract, delay is happening, the 1 year later, complete sequence is changed, progress is not same, legal path has changed. So that's surely not a suitable method, and I think one of the presentations we had seen that one. Second is as-built collapse. As-built collapse again, it is real complex. We really need, very very high skilled planning engineers, forestry planners to do that one. So most easy or the best method which gives the best results. Of course, not the 100% true, but best results are these two methods, which is time impact, which is updating, which is impacting the program based on the progress update. Progress update will surely show a true picture of the progress, and if you are putting the impact, it will show a true picture. Or if you are doing retrospectively, then we are comparing the two actual updates. Progress update the 3rd month, progress update 4th month, what happened between that period, which of the paths are delayed. So I think those methods, if you are putting in the contract, I think that surely reduces the scope of argument later. And these two, and even if it's not from my own view, this method, and if you see any court case, any arbitration, finally, these methods were preferred by most of the courts and all. Of course, one court, in my case I can't remember, one court, the case that was so frustrated with the different, planning engineers which came with a different, extensive delay analysis, he will just keep aside and I will do, what I feel fair. So yes, but when the judges or arbitrators are relying on this kind of delay analysis, these two approaches are, at that most of the time are preferred. So why not put this? And I know one client now, a major client in Dubai, who has actually put these two methods as in the contract.
In forming a contract based on 1999 editions, there is no provision for under recovery like 52.3 class is not there. So it is a sensitive issue there. So how to
Under recovery, you are saying that because of contract price going down, or going, but that under recovery, correct?
under recovery or over recovery?
No,
2.3 class.
No, if you read the contract, I think number I can't remember, but there is a provision whereby the under recovery can still be, under one of the clause can be recovered. But over recovery, there is no provision for the client to detect that over recovery. So, fitting 99, I can't remember the clause number, but there is a clause from which we can imply that under recovery contractor can recover. But you are right, it is not very clear. The way it was clear in fitting 87, it is not that clear. So, I think this thing is a right, a very valid question, and one of the model draft conditions which I was telling, one of the client has come up based on fitting 99. They have made it very clear in their now in the modified condition, clearly saying in case the contract price goes instead of 15%, they have made it 30%. They have, in that particular clause, they are very clearly said if it goes above 30%, then it will be recovered. If it goes below, then it will be paid. In the fitting 87, if you see, that also is not clear. Most of the time, even I used to think that if it goes up, we have to pay to the contractor. If it goes down, we have to recover. But it is vice versa, correct, actually. So better to, I think, make it clear once for all that under recovery or over recovery, if that is intended. So
Another question is when the breakdown they give in overhead and profit.
Yeah.
See this overhead they are not very specifically clarifying. This overhead is covering head office overhead. They put 8%.
Yeah.
The 8% covers sometimes include the financial charge, everything. They put in the preamble, this overhead covers the financial charge, insurance till the material come to site like that.
No, see, whatever, yeah. Okay.
But the head office overhead, whether we can make the breakdown of 8%, 6% for other overhead, 2% head office overhead, for clear UOT calculation, this is very important to show the overheads. The overheads are overhead.
No, see, overhead, what is stated in the BOQ breakdown, that is head office overhead. Let it include anything, whether finance charge, whatever. But end of the day, if the BOQ, and that is what the contractor has intended to recover. Say it's a 500 million contract and he has put 8% overhead in the BOQ breakdown, 8% of 500 million, he has intended to recover 40 million, correct? So 40 million he needs to recover, whether it is for head office, whether it is for site office, whether it is for anything, doesn't matter. Because end of the day, if the contract value is going down, he is not recovering that 40 million. So he needs to recover that one plus depending on the tolerance plus minus 15%. So if he is not recovering, not withstanding anything, whether it is site office, finance, he needs to be paid or vice versa. The site office overheads are normally in the general item, but doesn't matter. If contractor say put general items, a prelims, and a part of the site overheads he has put in the breakdown, still no need to split that because the contract says site and general overhead. It is not saying only head office overhead. Head office overhead, why we say that use the term, because we feel that all the site overheads are in general item and this percentage is only for head office overhead. But if you see contract, it says site and general overhead. So end of the day, the purpose is that if the value is going down, he is not recovering what he wanted to recover through that item, so which you have to give him. That correct.
Any omitted work, suppose out of 500 million, the employer omitted during concession stage. So 200 million omitted. So the contractor is, suppose the loss of profit is going. So in this case, here any provision, but there some people they put preamble clause. The contractor not entitled for loss of profit.
No, see, omission, again on omission, there are two ways to deal with omission. First thing is, this is a variation, and variation has to be dealt based on the BOQ rates if it is applicable or similar. That means we are omitting any works, we have to assess based on the BOQ rate. And what is BOQ rate? BOQ rate includes profit. So we have to omit everything. So it means the loss of profit claim in that context is not valid because omission is also a variation, and that evaluation of variation is under 52.1 in old fitting. 52.1 says to use BOQ rate. So that, your other point that whether overheads or not, so that overheads will be not recovered for paid at that point of time. Let the omission be there. Let end of the contract, when the statement completion is being issued, that time we will see. If it is really all omissions, then we have to pay him whatever overheads he has lost, plus minus 15%. Yes.
Yeah, in extension to his question, under recovery.
Yeah.
What about on remeasurable contracts due to remeasures?
No, yeah, I think that doesn't matter. The remeasurable or lump sum, the concept remains same. Because under that contractor has intended to recover some amount towards his overhead, and that overhead he has put in the BOQ price. Whether it is remeasurable lump sum, that doesn't matter. So now if it is lump sum, in that case, if there are no variation, then he is recovering that and no issue. But because of some omission in the lump sum contract, if you are omitting any work, then again the same issue. He wanted to recover X amount, but because of omission he is not able to recover, so he needs to be paid to that. A similar issue on remeasurement.
Remeasurement is already taken, consider the risk.
No, risk up to certain percentage. So contract clearly says that upon completion of the work, as a result of remeasurement and the variation, everything has to be clubbed, and then we need to compare that cost to the effective contract price and then see. So risk is taken, but up to a certain percentage, and vice versa client also. In case price goes up, in that case, client need not that plus 15% risk and minus 15% risk of monitor. Beyond that, each party has to pay or recover whatever the way.
Thank you. Is the extension that is being asked?
The same question actually. The reason there was an issue, a bill which has work value of 300 million, another 100 million provisional sum is there, and the overhead and profit is written as a separate part, line item, 10% for this 400 million. So it's 40 million separately.
So the total is value
440.
440. Okay. Yeah.
And the provisional sum deleted. So the preamble says the contractor is not entitled for the omitted. So how do we address?
Sorry, maybe the sound was there. So your question is 100 million provisional sum was there, 40 million.
300 million.
300 million, no issue.
100 million provisional sum.
Yes.
And there is a separate line item part for overhead and profit.
Profit, yeah.
10% for 400 million, both items taken.
Okay,
That's
okay.
40 million.
Okay, that's
So the
fine.
provisional sum deleted.
Okay.
The preamble says that the contract is not entitled for profit, loss of profit in case the work is omitted.
Okay, that's fine.
So how do we administer now? When the proportional sum delete, the proportionate profit also be deleted?
No. Since it says a loss. Now in this case, product has lost the profit on the provisional sum, which if he would have extracted, he would have made the profit out of that sum. And the contract says, in case of any omission or variation, he is not entitled for loss of profit. He is not entitled, correct? So in that case, I think that is clear, correct? If he has lost the profit because the work against the provisional sum was not extracted, so there that clause will come handy. That is, you are not entitled for loss of profit. So why should? So surely in that.
So the profit can be deleted.
No. The profit, how it comes into picture, that.
No, it's a bill item, it's separately.
No, I understand. See, if that now this overhead profit, that 10% or whatever, it was as a sum item or as a percentage item.
Percentage,
correct? Yeah.
400 into 10%.
Exactly. So, but surely, how we have to monitor the 10%? We have to monitor that 10% on the value of the work done. So out of 300 million is then we are paying 10% there. And this issue would have been a little bit more, complex if instead of percentage, a sum was there. Then maybe a little bit more argument. If the percentage is there, then I think it will be more, in favor of the client to straight away say that this what you are doing, we are paying for you. What you are not doing, we are not paying, especially there is a clause saying that in case of omission, there is no loss of profit.
They display, they put provisional sum item, they write in the line. Provisional sum item 100 million which showed. Is expended or not on the discretion of the employer.
Correct, correct.
They are not making a statement.
Sure.
With effective contractor is also the provision sum are not taken.
Correct, correct. So this is provisional sum is not paying, so there is no question of, even suppose there is no clause, still, if we say in a fair and ethical way, surely is not entitled because he is not doing that. Similar issue comes, sometimes in the lump sum contract, the day work component is there. And there is no day work is done, then the contractor's argument is that, it's a lump sum contract and I should be paid for those day work whether I done or not. This argument, sometimes it becomes a little bit tricky, and I know one or two contractors were able to win this argument. They were saying, okay, lump sum contract, day work was a sort of risk or whatever, and we have priced that risk, and now it is going up or down. We should not change, and it is not done so. But that's why most of the contracts nowadays are clearly saying, especially for day work and provisional sum, most of the contracts do say it is the discretion of the employer. If it is done, then it will be paid and it will be expanded at the sole discretion. So I think most of the contracts now they are saying, especially for the provisional sum and day work, to avoid this unnecessary argument.
I think now we need to.
Yeah.
There is one consultancy contract in which there is a percentage fee against the awarded construction contract sum.
This is consultancy related, and the answer is payable.
Construction package, there is a 400 million awarded sum.
Okay.
In which 100 million for the provisional sum.
Okay, understood. Yeah. No, I think I know this.
Yeah. But when the design fee finalized, the fee to be paid against the 400 million as per the concept. 5% against.
Okay.
But when the provisional sum awarded,
Yeah.
the amount of provisional sum, actual provisional sum, dropped to 50 million instead of 100.
Okay.
Then the fee for consultant should be considered against the 350 over 400.
I think this is most of the brands in Dubai who are dealing with the major brands in Dubai, they have made this very clear in the contract. And I will come to your question also. In their contract, what it clearly says, the consultant fee, which is based on the percentage, that has to be valued based on the total contract value minus the provisional sum, and unfortunately they have made minus the general items of the construction contract. Anyway, in your case, leave the general items. So the right thing would have been if the contract would have said the consultant fee in the percentage will be applicable on the total value minus the provisional sum, and in case any design is done by the consultant later based on the provisional sum, then he will get his percentage markup or fee based on the construction value of that work which he designs, and we obtain the price from the contractor. But in your contract now, we have not read your contract, exact line we need to read. If it clearly says that this percentage for the fee shall be reimbursed on the total contract value, and when the percentage is there, in that case there are two scenarios. Okay, one scenario is that the consultant, when he quoted for his fee, he would have assumed that 400 value, yes, 300 million I am designing now, 100 million surely during course of the work I will design, and based on that, what cost I am going to incur in number of hours, that cost divided by 400, that is the percentage, and he has quoted. Now, if the 400, if that 100 becomes 50, or 100 may become 150 also, correct? In that case, if it becomes 50, it is your claim or your client, correct? If it becomes 150, then it becomes the consultant's claim. In that case, since the contract does not have an express provision that in case the provisional sum goes up or low, how it is going to be treated, then in my opinion, the test of reasonability or anticipation has to be taken into account. That if you are telling a consultant that this is the value, this is the provisional sum, what additional risk he could have assumed for 100 million provisional sum? Should he have assumed 20%, 25% plus that this sum can go plus minus depending on what prices we get from the contractor later, or vice versa, like plus minus? Could he have assumed that it will go to 75? Yes, maybe yes, because it was not defined. So this kind of risk, he has assumed that plus minus 15-20%, or sometimes go up and down. But if the sum is going more than 15-20%, it means here the test of reasonability if you apply, that client would not have anticipated when he was putting the clause that he will get fee on 400. He would not have anticipated that 100 million will go to 50 or go to 10. Right? Surely, so in that case, based on the test of reasonability, in my opinion, client should have claim or not claim is he should be based on that reasonability factor, he should say that the clause does not say that plus minus how much, but that's fine. I'll at this stage I'll assume that it is plus minus 25%, not more than that. So up to 75, it is your right. I will not deduct anything, but for 25, I think you need to. So I think but in the next contract you need to make it clear. But for this contract, if I was in your place, maybe I could have tried to argue this way. But again, there is no yes or no answer because contract is a little bit ambiguous. But in these kind of things, where contract is silent and there is some issue, and one party is becoming, like they call it the term, unjust enrichment. In that case, even the matter goes to court, they will see that that is really unjust enrichment fair. Any court will say no. Suppose same thing, 100 million provision fund becomes zero. In that case, consular should get this fee. Ideally no, because he is becoming unjustly rich by getting that money. So in that case, surely courts also may try to interpret that yes, some reasonable risk plus minus fine, but beyond that, parties should have the right to not to pay or to pay more in case. So that is my take on this.
Okay, thank you very much. I think it's very clear our guidelines. And on behalf of our IIPS Global Board and UAE Committee, I thank you, Mr. Dharmendra, for his wonderful lecture. And also thank you very much everyone here taking your time and coming here and making this event very successful. Thank you very much.